The title of today's hearing is Lessons from the Mueller Report, Part 3, Constitutional Processes for Addressing Presidential Misconduct. As many of you may already know, the subtitle is a quote taken directly from Volume 2 of the Mueller Report, where the special counsel describes why he did not reach a, quote, prosecutorial judgment, close quote, regarding President Trump's conduct. There, the special counsel explained that as an attorney operating within the Department of Justice, he is bound by department policy, including an Office of Legal Counsel opinion that asserts that a president is immune from prosecution while in office. The special counsel, quote, recognized that a federal criminal accusation against a sitting president would place burdens on the undue burdens on the president's capacity to govern, close quote. Yet the Mueller report also acknowledged that such an accusation could, quote, potentially preempt constitutional processes for addressing presidential misconduct, close quote. The special counsel's mention of these constitutional processes should not be taken lightly. It goes to the heart of Congress's role in our constitutional system of checks and balances, and that is the subject of today's hearing. As the Mueller report's frequent references to Congress make clear, Congress has a role in investigating the potential presidential misconduct he uncovered so that it may determine how best to exercise its Article I authorities to act as a check on the abuse or misuse of executive branch power. In light of its jurisdiction and past precedent, this committee in particular has a constitutional duty to investigate allegations of misconduct by executive branch officials, including the President of the United States, and is currently investigating allegations of abuse of power, public corruption, and obstruction of justice within the Trump administration. The purpose of this hearing is to examine the range of constitutional remedies available for addressing presidential misconduct under its Article I authorities. Today's discussion will aid the committee in determining the remedies available to it as the investigation unfolds. Under its Article I authorities, Congress has a number of responses to presidential misconduct available to it. With regard to the committee's responsibility to determine whether to recommend articles of impeachment against the president, articles of impeachment are under consideration as part of the committee's investigation, although no final determination has been made. In addition, the committee has the authority to recommend its own articles of impeachment for consideration by the full House of Representatives. The committee seeks documentary evidence and intends to conduct hearings with Mr. McGahn and other critical witnesses testifying before us. That is necessary to determine whether the committee should recommend articles of impeachment or any other Article I remedies, and if so, in what form. The committee is also considering other responses to the conduct under investigation. While censure of the president is rare, Congress has previously passed measures expressing disagreement with specific presidential conduct. The committee is considering several pieces of legislation that would address the allegations of misconduct uncovered by the special counsel's investigation and other serious policy concerns raised by the Mueller report. Legislative proposals to deter misconduct described in the Mueller report include measures that would increase transparency with regard to White House communications concerning law enforcement investigations. Those proposals also include measures to impose additional safeguards to protect the integrity and independence of future special counsel investigations. The committee also has been referred proposals to amend the Constitution to limit the scope of executive clemency and legislation to increase transparency regarding presidential pardons, which responds to additional fact patterns described in the report. Volume 1 of the Mueller report also documented numerous troubling contacts between the Trump campaign and individuals associated with the Russian government. As a result, several members have introduced legislation that would impose a duty on campaigns to report their contacts with foreign governments. With regard to possible criminal, civil, or administrative referrals, the Justice Department has discretion as to whether to act upon a referral by Congress for prosecution or civil enforcement. As even DOJ policy acknowledges, a president is not immune from criminal prosecution after leaving office. And I have introduced legislation that would toll the statute of limitations on federal offenses during a president's term in office. State authorities may also enforce state laws against the president. The congressional referral process serves the important purpose of creating a record and preserving evidence for such time as prosecution, civil enforcement, or other administrative response is feasible. The committee cannot, however, determine which Article I remedies are appropriate without first ascertaining all of the relevant facts, and it cannot do so when the administration refuses to cooperate with legitimate congressional oversight. That is why today's hearing will also give the committee the opportunity to consider the lawfulness of the administration's efforts to limit congressional oversight requests. The Trump administration has asserted that several current and former government officials are, quote, absolutely immune, unquote, from having to comply with congressional subpoenas for testimony. However, the only court to ever consider such claims rejected them in a case involving this very committee's past effort to seek information about inappropriate White House involvement in the firing of several U.S. attorneys. In addition to asserting claims of absolute immunity, in quotes, the White House has instructed several witnesses not to comply with the committee's duly issued subpoenas for documents or to answer questions on the basis that the documents and answers are subject to executive privilege or would otherwise, quote, implicate constitutionally based executive branch confidentiality interests, close quote. Needless to say, these assertions raise a host of problematic legal and constitutional issues. We have a distinguished panel of witnesses who can help us sort through the various constitutional processes implicated by the Mueller report, and I look forward to hearing their testimony. It is now my pleasure to recognize the ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman. I was sorry. For a moment, you ever have one of those dreams? You know, I thought there's been movies about this. You have a dream that you wake up and you're back in school. You're back in high school. For me, it was back with Miss McCall's class in North Hall High School, American government class. And it's the proper role of government and the different checks and balances and, you know, what is Congress's role and what's the president's role and what's the judiciary's role. We can stop this hearing right now because the chairman just laid out all the congressional routes and avenues that Congress has to it. And we're going to have a time, and I'm glad the panel's here. Y'all are great folks. You've got scholarly work. We're going to hear some wonderful things. But we've stopped right here. The problem is we're just dragging this on. It's not that you want to come to impeachment. The chairman talked about impeachment. If that's what you want to do, then that's the part. We don't need to discuss, is this a constitutional right of Congress to do impeachment? That is exactly what Congress is right to do. The constitutional processes are very well addressed in the Constitution and in our processes. But instead, we come here today to have another almost impeachment hearing, but not an impeachment hearing. We want to get facts. We want to do this. No, we're just waiting on and on. I'm trapped back in 9th grade. Miss McCall was a wonderful teacher, but I don't want to go back through it again. This is black and white. We know this problem here. So what are we not doing? Instead of this morning at 9 o'clock on a Friday on a fly-out day when we are actually, the chairman and I have a bill on the floor here in just a little bit that actually touches real people's lives in New York from the 9/11 fund, which is a very valid thing that we need to be doing. Yesterday, we spent this entire committee time arguing over subpoenas and the discussion on the border, but yet, why wouldn't we use this 9 o'clock time to actually have a markup of actual immigration bills, such as mine, that addresses border issues? Now, you may disagree with what I propose, but that's what markups are for. That's what actually is taking this time, and you have a bill. Put your bills up. Let's actually get to actually solving real issues instead of having theoretical college discussions on what is Congress's power. If we don't know what Congress's power is now, this hearing's not going to help us. In fact, it's ridiculous. Legislation, I agree with the chairman. The chairman talked about election, which actually the Mueller report actually found election interference. Why aren't we putting those bills forward instead of having our authority taken over by the House Admin Committee on election bills because they don't want to run it through here? Let's solve problems. Process. Here's our biggest thing from yesterday. And maybe this is it, is what the process is. We know what the process is. The majority just can't find their way to figure out what they want to do with that process. And so next week we have Robert Mueller coming in here, and the whole bottom row is disenfranchised for the most part. I guess there's some more negotiations going on. I've read that in the media. Maybe I need to call Chairman Schiff and make sure that that was okay, because they were undoubtedly driving this ship, because they all get to talk next week. My side doesn't, and neither does the Democratic side get to talk. It disenfranchises Florida, it disenfranchises North Dakota, it disenfranchises everyone. But instead of that, we're doing this. It just frankly boggles the mind. But I will say this. if there's anybody on this committee, and there are very wonderful people on both sides of this committee who are very, very intelligent. And you can ask your questions today, and we can talk about the constitutional process, and you've got some great folks here to talk to you about it. But in all due respect, we know what the constitutional process is here. We just want to dance around it so we can keep another round of stories going that the Judiciary Committee is pursuing and harassment and doing what it needs to do to make sure this administration is held accountable because we don't like him. The economy's good, life's going better, and we don't like it because we don't like the November 16th election. That's all this is about. We found that out again yesterday. We're going to find it out again this morning. So for everybody who didn't get to the wonderful ability to be in Miss McCall's 9th grade American government class at North Hall High School, this may be your opportunity. Get your horn books out, get your study books out. This is going to be a constitutional process of what we already know is our processes, but we're going to have some experts tell us what those processes are. Mr. Chairman, there's a lot of things you could be calling today. This isn't one of them. Why don't we actually take up real legislation to fix the border crisis, to fix the issues that we all talk about up here? Instead, we have hearings. Our body is to actually legislate. You and I have legislated before. Let's start legislating and stop the show. But as again, the popcorn's cooking. It's time, as I've always said, let the show begin.
Thank you, Mr. Collins. I will now introduce today's witnesses. Carolyn Frederickson is president of the American Constitutional Society for Law and Policy. And previously, she was the director of the American Civil Liberties Union's Washington Legislative Office, held various positions in the Senate, and served in the Clinton administration. Ms. Frederickson received her JD from Columbia Law School, in my district, and her BA from Yale University. John Eastman is the Henry Salvatore Professor of Law and Community Service and the former dean at Chapman University's Dale Fowler School of Law. He also serves as director of the Center for Constitutional Jurisprudence at the Claremont Institute. Previously, Dr. Eastman served as a law clerk to Justice Clarence Thomas and to Judge J. Michael Luddig. Dr. Eastman received his PhD from Claremont Graduate School, his JD from the University of Chicago Law School, and his BA from the University of Dallas. Michael Gerhardt is the Samuel Ash Distinguished Professor in Constitutional Law at the University of North Carolina School of Law in Chapel Hill. Professor Gerhardt served on then-President-elect Bill Clinton's Justice Department transition team and drafted the administration's judicial selection policy. He later served as special counsel to the Clinton administration and the Senate Judiciary Committee. Professor Gerhardt received his JD from the University of Chicago Law School, his MS from the London School of Economics, and his BA from Yale University. We welcome our distinguished witnesses, and we thank you for participating in today's hearing. Now, if you'd please rise, I'll begin by swearing you in. Would you raise your right hands? Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief? So help you God. Thank you. Let the record show the witnesses answered in the affirmative, and thank you, and please be seated. Please note that your written statements will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time, there's a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals your 5 minutes have expired. Mr. Frederickson, you may begin. Ms. Frederickson, I'm sorry, you may begin.
Good morning. Thank you, Mr. Chairman. My name is Caroline Frederickson. I'm the president of the American Constitution Society. ACS has worked to promote informed public evaluation of the investigations into Russian interference in the 2016 election. It is with this background that I'm pleased to testify on the constitutional processes for addressing presidential misconduct. The final report issued by Special Counsel Robert Mueller on Russian interference in the 2016 election reached several chilling conclusions. Russia conducted wide-ranging attacks on our nation's election system. The Trump campaign had multiple contacts with Russian nationals and did not report these interactions to U.S. authorities. And there's substantial evidence that President Trump repeatedly attempted to thwart the investigation, including through his unheeded request to the White House counsel to fire the special counsel, create a false paper trail, and make public misrepresentations regarding this incident. To say these findings are troubling is an understatement. It is Congress's constitutional duty to respond. Close examination of how Russia executed these interference strategies is necessary to inform this committee and other committees of jurisdiction how to best tailor a wide range of legislative initiatives on subjects from electronic data protections to the provision of additional funding or resources for U.S. agencies responsible for monitoring and investigating foreign interference, to the integrity of special counsel inquiries, to ensuring limits on political interference with Department of Justice decision-making. Although congressional oversight might eventually lead to impeachment, it does not have to do so. The Supreme Court has long held that Congress's oversight authorities are inherent in the Article I legislative powers. These authorities are broad and encompass matters including, quote, the administration of existing laws, proposed or possibly needed statutes, and probes to expose corruption, inefficiency, and waste. Indeed, the Court has emphasized that oversight is essential to the conduct of government. This committee has additional constitutional authorities to conduct oversight under Article I, Section 2, stating that the House of Representatives has the sole power of impeachment. Congressional investigations often lead to new laws, but some investigations have led Congress to conclude that enacting new laws is not necessary to address issues identified in the inquiry. Sometimes congressional oversight has led to executive branch reforms. Other times, inquiries into alleged administration corruption have resulted in resignations, referrals, House or Senate resolutions memorializing disapproval of presidential or other administration misconduct, or impeachment proceedings. Congressional oversight history is replete with investigations into alleged White House misconduct that did not involve impeachment. Many involved testimony from top White House aides, including White House counsels, chiefs of staff to the president, national security advisors, and top advisors to the vice president and first lady. Impeachment proceedings have begun without any formal vote of the House. In addition, for presidential impeachments, the Judiciary Committee has conducted hearings to determine whether or not to recommend articles to the full House. In the impeachment of President Nixon, the House Judiciary Committee had been considering articles of impeachment for close to a year before there was a full House vote in February 1974. With respect to the Mueller report and related information, several key unanswered questions demand rigorous congressional review. For example, how can Congress best protect our elections from future attacks by Russia or other hostile nations? Why did Trump campaign officials, associates, and then candidate Trump continue to have contact with Russians after becoming aware of the hacking? Why did some lie to investigators about these contacts? And why did they suggest publicly that Trump, quote, had nothing to do with Russia? Does the substantial evidence of obstruction of justice and other misconduct merit further congressional action, including legislation, censure, impeachment, or referrals? And finally, does the content behind the Mueller report redactions and gaps in evidence suggest any additional wrongdoing by the president or others? Congress's job has been made substantially harder by the administration's intransigence in resisting congressional oversight at every turn, instructing officials to disobey congressional subpoenas, and invoking broad claims of executive privilege. And it has gone so far as to claim that this committee even lacks authority to investigate these matters in the first instance. Given the gravity of the Mueller report conclusions and the related information that has emerged publicly to date, a failure by Congress to examine these issues would constitute an abdication of Congress's fundamental constitutional oversight responsibilities. Thank you.
Thank you. Dr. Eastman? Can you speak into the mic, please?
Sorry. Thank you, Chairman Nadler and members of the committee. I'm delighted to be here to participate in this hearing. But before turning to the substance of my remarks and addressing the precise question you've posed, I think it's important to take issue with the underlying assumption of the hearing contained in the full title of this hearing. By tying the question of presidential misconduct to the Mueller report, you imply that the Mueller report identified presidential misconduct that should trigger whatever constitutional processes might be available. As a factual matter, I could not disagree more, for I do not find anything in that report even remotely rising to the level that would trigger the one constitutional path designed to address presidential misconduct, and that's impeachment. I should also note that this is not the first time the Congressional Judiciary Committee has considered this question. In 1998, the Senate Judiciary Committee's Subcommittee on the Constitution held a hearing on impeachment or indictment. I commend the proceedings of that hearing to your attention, particularly the extremely persuasive testimony and submitted scholarly work of Yale law professor Akhil Amar. The conclusion he reached then is the same one I reach now, and it is the same one that has been reached by the Office of Legal Counsel in both Democrat and Republican administrations spanning nearly a half a century. Because of the unique role the Constitution assigns to the office of president, a sitting president cannot be indicted. That does not place the president above the law, as some have claimed, but it does recognize that the sole remedy envisioned by the Constitution for illegal conduct by a president while he is president is the impeachment process outlined in Article 1, Section 3. As Professor Omar so aptly put it, the grand jury in such a case is the House, the indictment is the articles of impeachment, and the Senate is the petit jury. I won't go through the conclusions of those two OLC reports other than to very quickly summarize them. The notion that the president can be himself a criminal defendant in a federal prosecution would put him on both sides of the criminal prosecution. He is, after all, the chief executive of the nation, responsible for the prosecutorial function of the federal government. It's also true that he has unique official duties that no one else in the government has, most of which, as the OLC report in 2000 under the Clinton administration acknowledged, most of which cannot be exercised by anybody else. That strongly counseled them, both OLCs, to conclude that the president could not only not be tried or incarcerated if convicted, but not even indicted, because it would amount to such a fundamental intrusion on his executive duties and therefore impact greatly the entire nation. But there's a third thing that the OLC report in 2000 offered that I think is even more dispositive. The president's role as guardian and executor of the 4-year popular mandate expressed in the most recent balloting for the presidency. To allow a single prosecutor or a single grand jury, regionally drawn in some place in the country, the ability to incapacitate a president who had been chosen through a national election by the people, by the whole people of the United States, is really contrary to our basic system of government. That's why the OLC concluded the decision to terminate the mandate is more fittingly handled by the Congress than by a jury. And I think I want to close by looking at those OLC reports. They focus on the fact that the impeachment process is done by elected members of Congress who are politically accountable. And it's that piece that I want to focus on. Because if there is indeed anything in the Mueller report that rises to the level of treason, bribery, or other high crimes and misdemeanors, then the members of this body will likely be held accountable politically if the House does not initiate impeachment proceedings. But the flip side of that coin is also true. If, as I believe is clearly the case, nothing identified in the Mueller report remotely rises to that level, then the members of this body who continue to pursue impeachment investigations and even formal impeachment proceedings that manifestly appear to the public to be an attempt to distract the president from the performance of his constitutional duties, or worse, to negate the results of the 2000 election, then they too should be and likely will be held politically accountable. That's why the Constitution assigns this awesome oversight authority to this body, but it comes with the political accountability that flows from that. We can get into the question and answer about the specific instances, but I think that the various instances that are alleged for obstruction of justice or Russia collusion pale in comparison to some of the things we know occurred by the prior administration. And it's that level of comparison that I think the American people will ultimately choose to make as the political accountability for this committee and every member of the House of Representatives as they continue to pursue these things. Thank you for your attention.
Thank you. Professor Gerhardt?
Thank you, Mr. Chairman. It's an honor to be here today, an honor to participate in today's hearings, and to be a part of an important discussion about constitutional processes for presidential misconduct. A good place to begin our discussion, I believe, is with the Supreme Court's decision in Nixon versus Fitzgerald, a 1982 decision by the Supreme Court that held that the president is immune to civil lawsuits seeking damages based on his official conduct. Near the end of its opinion, the Supreme Court recognizes a number of other ways in which the Constitution allows for the president to be held accountable for his misconduct. There are formal mechanisms, for example, such as impeachment, such as congressional oversight, such as popular elections. That allows for considerable opportunity and, in fact, legitimacy for this committee and Congress to consider which, if any, possible ways it wants to consider for holding a president accountable for his misconduct. There's long history here, but let me cut to the chase. The first mechanism, congressional oversight, is, of course, of long-standing legitimacy. The Constitution does not require that this House follow any particular procedures in trying to determine whether or not and how it may hold a president accountable for his misconduct. In fact, just the opposite. Article 1, Section 5 of the Constitution vests each body of Congress, the House, the Senate, with the authority to determine its own internal rules of governance. The committee today is doing nothing more than following through in accordance with the House rules. That's all that's happening. It's as simple as that. Besides congressional oversight, there are, as we've recognized, other mechanisms. One of them, of course, is impeachment. I won't dally on that right now, but one thing to recognize about the possibility of impeachment is that the House, and particularly this committee, is fully entitled to consider what evidence there may be on whether a president committed misconduct, but also what other evidence needs to be determined in order to reach a decision about whether or not to proceed further on any particular process relating to presidential misconduct. It's that simple. The Constitution does not require a series of hoops that this committee has to go through in order to make its determinations about what, if anything, to do with presidential misconduct. Just the opposite, as I said. The Constitution vests considerable authority in each chamber to determine its rules of governance, and here the committee is following through on that. Another mechanism we haven't discussed but could is censure. I have long believed that censure is a legitimate option for this committee to consider if and when it encounters or finds that a president or any other official has engaged in misconduct. The authority isn't just derived from the fact the Constitution doesn't disallow censure. The authority is established by long-standing traditions and exercise of power within this body. For example, when Abraham Lincoln was a member of the House of Representatives, he introduced a resolution criticizing President Polk's initiating, in his opinion, the illegal Mexican War. His resolution didn't pass, but he did vote for a resolution that did pass, 82-21, holding President Polk accountable for unnecessarily initiating an unlawful war. That's good enough for me. President Lincoln thinks it's good enough for the House. I think it's long-standing authority we can follow. Other mechanisms, of course, involve possible lawsuits. Civil lawsuits based on unofficial misconduct have been recognized in Clinton versus Jones as legitimate, and they may proceed. In addition, of course, there may be the possibility of criminal trials. One thing to understand about the possibility of criminal trials is, as Dr. Eastman just suggested, that there's a long-standing debate on whether or not a sitting president may be subject to criminal process. I believe so. I've set forth my arguments in my written statement. I won't expand on them here, but I'm happy to answer questions about it. And of course, a final thing I hope you'll allow me to just finish with is something that Raoul Berger, long recognized as one of the great authorities on impeachment, said 30 years ago in the New York Times. He said, by refusing to comply with the subpoenas of the House Judiciary Committee, President Clinton is setting himself above the Constitution. No president is above the law. No president can use his authority or any of his powers to thwart the powers of this body and therefore to be above and beyond any accountability to the law. Thank you very much for the opportunity to be here today.
The committee will now stand in recess for 5 minutes, and Democratic members will meet over here, and the Republican members on their side. This will be a 5-minute recess.
And we'll now proceed under the 5-minute rule with questions, and I'll begin by recognizing Mr. Collins.
And I thank the chairwoman for doing that. We've got to go to the floor and take up the 9/11 bill, so I appreciate that. And I probably won't be long, but Mr. Eastman, let's talk just for a moment. Do you think there's any possibility that this group of attorneys and non-attorneys on this Judiciary Committee have any, or their staffs have any problem understanding the constitutional role of Congress in oversight of the administration, on any administration?
I don't know the background of every member, but I think the usual member ought to know the answer to that.
And that would come from just, if nothing else, life growing up and taking, government classes going up, correct? Well, that's good. One of the things I want to be interested in, and there's a lot of things that people will talk about today, and we'll get into a lot of different things, but one of the problems that I've had here, and we talk about constitutional process, we also talk, and the professor here talked about our internal processes and going on, and one of the things that I've been just very disappointed in our committee for the last 6 months is our way we handle subpoenas and the way that we have went through contempt and how we have rushed through this process and how you're familiar with subpoenas, correct?
Yes.
And how they should operate. Has a subpoena ever been, from a perception that you ever had, would a Black's Law Dictionary of a subpoena say that it is an opening to a dialogue?
No.
Would it ever be said that a subpoena should be to enhance your standing in court?
No.
Okay. If that be true, then my question is, do you believe that it hurts us as an institution when we rush through these issues of contempt and subpoena? And I'd love for you to talk about that for a minute.
Well, look, I want to take up, I agree with most of what Professor Gerhardt said. The one point of disagreement I have is I don't think he gave enough credit to the notion that these fights over congressional subpoenas and congressional testimonies by the executive are ones that arise out of a deliberate design function of the Constitution, which is a separation and a counterbalance of powers. Yes, the Congress has oversight authority, but there are limits to that authority, and those limits we typically classify generally as executive privilege. And so most of the fights in our nation's history over the issuance of subpoenas and the testimony of high-ranking executive officials deal with that counterbalancing authority that the executive has. Congress cannot, in its oversight capacity, intrude on the executive functions, including the confidentiality of presidential communications. And I think that's well established as well. And the fight then is over whether this current round of subpoenas and demands for testimony are really designed to intrude on the executive in an unconstitutional way. And I think that's where the conversation has to focus.
You talk about conversations and dialogue, and this is one of the things that I've been in Congress, not my life, but the last 6.5 years, and I've noticed the battles that go between both Democrat and Republican administrations in the Hill. This has been going on forever. Do you believe it's good, and I got several questions here, do you believe it's good for a committee just to lead with no conversation with an individual, or to lead with a subpoena?
I don't. I think there's a lot of negotiation that has historically gone on those issues.
And we have went to the floor for contempt on very limited terms, especially with the Attorney General, and a shortened time here. The question that I would have here is, if you look at this from a judge's perspective, when they say, and we talk about, and by the way, this committee seems to be unique in this because other committees, such as the Intel Committee, actually negotiated and began to get stuff in the proper way of back and forth and back and forth. When we go to, if we were to try and enforce one of these contempts that we have done with lack of foundation, lack of background, do you believe it hurts this committee and this institution as a whole?
I think it would certainly undermine the claims in the court that the subpoenas or the efforts were made in good faith, and that would certainly undermine any court's plan on giving enforcement effort to those things.
I appreciate it. I know in my home county of Hall County, my judges would look at me and say, go back and do your job, and before you bring it to me. So with that, I do appreciate the chair's indulgence, and know that I'll yield back.
Okay, thank you. The chair recognizes Representative Lofgren for 5 minutes.
Thanks very much. I think this is an important hearing. I noted the ranking member's comment that we should be taking up other subjects instead of this one, and I can't help but recall that the Democrats, in terms of election security, as a first order of business, introduced H.R. 1 about election security and got no help from the minority party. And my own bill, the SAFE Act that we just passed 2 weeks ago, to harden election systems got only one Republican vote. So I think that's a bit disingenuous. Let me talk about the OLC opinion. I've been interested in that for some time, and I'm wondering whether Ms. Frederickson or Mr. Gerhardt, you believe that the OLC opinion would cover activities, criminal activities for any president that occurred prior to that president assuming office. For example, Spiro Agnew was left his position for bribery that was engaged in while he was in Maryland before he was vice president. What's your view on that?
Well, I think
your microphone's not on.
Just say two quick things, and then I think Professor Gerhardt probably has a more thorough answer. I'd say one thing is that I think the vice president is not covered.
Oh, I understand that. I just meant that as an example.
But I think that's just one of the weaknesses of the OLC opinion is it does seem to indicate that insulate a president from judicial process in a way that I think is not consistent with rule of law as understood by the founders.
One of the questions I've had, if I can throw at you, in addition, Professor Gerhardt, is there any limit to this? Let's say someday in the future, President A is annoyed with the vice president, pulls out a gun, shoots the vice president in the head in the Oval Office. That would be a federal crime. Would that President A in the future be immune from prosecution?
I hope not. And I respectfully disagree with the OLC opinion. Obviously, OLC does fantastic work. They're not right about everything. I mean, everybody is subject to scrutiny, and in this case, I think they got it wrong. I've long thought that the president is not special. Everybody in government is subject to criminal process, and should anybody in government commit a crime, they're not entitled to any immunity. I think that's the Constitution we have. In fact, to go back to your earlier question about whether or not a president, let's keep it hypothetical, commits a crime before he's elected. And nobody knows about it. If we find out about it later, it becomes almost absurd to imagine that the country has to somehow sit tight for 4 or 8 years until he leaves office before he is subject to a criminal trial. If that crime has any relationship to his election, and it almost certainly does because it would have affected people's votes to know about it, even if, then I think the Constitution gets turned on its head.
Let me ask you this. In terms of the OLC opinion, obviously they're just looking at federal prosecutions. We have 50 states. If the President A shoots somebody who's not a federal official in a state, that would be a violation of state law. Do you believe that the Constitution prohibits a state prosecution of a president for a state law violation?
I don't believe it does, but I also should just point out, for the record, that this committee and this House of Representatives has confronted this issue already, to some extent, in the case of Thomas Porteous.
Right.
Thomas Porteous was a federal district judge who nobody knew.
We were on the committee during the impeachment, so.
But I won't go into details if you don't want, but I think they're quite pertinent. The point is he committed criminal misconduct before he entered his office as a federal district judge. He didn't tell the Senate about it, and that turned out basically to be fraud against the Senate and was a basis for his impeachment.
Let me just ask a final question. If the DOJ opinion is correct, it seems a logical extension is that the federal prosecutors could not be expected to actually investigate a president. And when you think back to the Nixon impeachment, Jaworski was, provided information to the Congress. Certainly, Ken Starr provided us information. I was on the committee at that time. Presumably, that would not be permitted if you could not prosecute a sitting president. Is that, what do you think of that?
Time has expired, but you can answer.
Well, I think if there's, if a prosecutor finds evidence of obstruction, for example, then that may be an appropriate time to consider the propriety and legitimacy of criminal process. I think that no one, the very principle of no one being above the law means just what it says. Nobody's above the law. The president can't obstruct an impeachment question, how a House committee looking into the possibility of whatever misconduct he's committed, because if he could do that, then he really is above the law.
Thank you. My time is expired.
Thank you. The chair recognizes the gentleman from Florida for 5 minutes.
Thank you, Madam Chair. Mr. Eastman, you've commented on the potential harms that can come with a special counsel that's unbridled. Is there anything you'd like to add to that?
Well, I mean, I want to pick up on something that Professor Gerhardt said, the notion that the president would be above the law. One of the things that has troubled me about the OLC opinions, which I think are correct, is that potential criminal liability may not exist at all for a sitting president for conduct, either criminal conduct, either while in office or before, given the statute of limitations problems. Both OLC memos recommended to Congress that they could address that issue, and I would encourage you to do so. That would ensure that no president is above the law at the end of the day, but it would also ensure, and I think this is what the OLC memos are both based on, and they would apply whether the criminal conduct occurred while in office or before, the unique responsibilities of the president in our system of government and the ability of a single prosecutor or a single grand jury to interfere with that. And I think that's why the OLC memos are correct. But to remedy the one shortcoming from that, you could address the statute of limitation thing. And I think Chairman Nadler in his opening statement mentioned that that was one of the things that might be worth considering. And I would endorse that. I do think, though, that the reasoning of the OLC memos, implicitly in the first one and explicitly in the second, also extends, although for different, not separation of powers reasons, but for federalism reasons, to state authorities being able to indict the president. And I think they're right about that as well. That door is closed as well for the same reasons that a federal indictment against the president while he's sitting is closed. And I think that's right. It's a balancing act. But the balance, given the unique nature of the president's role and the unique nature of his election, the only one, say for the vice president, who's elected nationally, those two things have contributed to this immunity that the OLCs of both sides of the political aisle have recognized, like I said earlier, in over a span of 50 years. That doesn't keep the president off the hook, but it does shift the discussion to a politically accountable body where people can be held to account if they abuse the investigative process.
You made mention of the president's unique powers and how they interface with an analysis of proper versus improper conduct. And you also make reference to the dealing with Director Comey. Is there anything you'd like to add on that front?
Well, something that Chairman Nadler said in his opening that I disagree with, and I think is important to get out here. One of the pieces of legislation that is being considered is to expose White House communications with the Department of Justice to identify whether the president is having any role in prosecutorial decisions. I think that idea fundamentally misunderstands the nature of Article 2 of the Constitution, which says the executive power, all of it, is vested in the President of the United States. The Attorney General in its prosecutorial functions at the Department of Justice holds that power derivatively from the President. The FBI, in its investigative power, holds that power derivatively from the president. The notion that the president can't be the one to make the prosecutorial or the investigative decisions is to completely undermine that core aspect of Article 2. And so I think that idea is just simply misguided. Now, if the president decided that Director Comey, and I outline in my testimony why I think both sides of the political aisle in Congress were upset enough with Mr. Comey to have warranted removing him long before the president did, but the president had that authority himself. And I don't think that exercising an authority that he constitutionally has rises to the level of obstruction of justice.
Thank you, Madam Chair. I yield back.
The chair recognizes the gentlewoman from Texas for 5 minutes.
I thank the chair very much. I'm going to read partly a statement by former federal prosecutors, and I would also like to add, having been here in 1998 and also for a number of impeachment proceedings regarding federal judges, when Mr. Starr handed our friends on the other side of the aisle the Starr report, they immediately began impeachment proceedings. And that was the historical record that was created. I don't know if they were concerned about any factual basis other than the Starr report. In this instance, we are meticulously listening to scholars and interviewing individuals by way of subpoena and building the building blocks of the constitutional process, and as well the building blocks of the understanding of the American people. Each of us believes that the conduct of President Trump described in Special Counsel Robert Mueller's report would, in the case of any other person not covered by the Office of Legal Counsel policy against indicting a sitting president, result in multiple felony charges for obstruction of justice. They recount the president's efforts to fire Mueller and to falsify evidence about that report, about that effort, the president's efforts to limit the scope of Mueller's investigation, to exclude his conduct, and the president's effort to prevent witnesses from cooperating with investigators probing him and his campaign. Professor Frederickson, do you find agreement with 1,025 prosecutors, the possibility of such?
I have to say I've never been a prosecutor, but I think it's a very impressive list of some of our nation's most illustrated prosecutors who have engaged in lengthy careers. And I think I take what they say very seriously. I think it is very important for this committee to go further and examine the allegations that were laid out in the Mueller report.
And thank you. And I ask the chairwoman to ask unanimous consent to place a statement by former federal prosecutors. Part of what I just read, 1,025 indicate that the president would be subject to felony charges if he was not the president of the United States. Let me also make mention, thank you very much, of HRES 396, a resolution of investigation, Professor Gerhardt, and welcome to all of you, by the way. Thank you so very much for your presence. It recounts, it's under our Rules 6 and 7 of House Practices. It is an instruction for the Judiciary Committee to investigate, but included in the resolution, it indicates various elements of investigation: violation of the Foreign Emoluments Clause of the United States Constitution, violation of the Domestic Emoluments Clause of the United States Constitution, obstruction of justice, abuse of power, misfeasance in public office, malfeasance in public office, failure to protect the confidentiality of national secrets from enemies, foreign and domestic. Just a litany similar almost to articles of impeachment. But let me ask you this. In your written testimony, you note that the theme that clearly emerges from early discussions of the scope of impeachable offenses are that they are not neatly delineated but depend on context and gravity, of which the responsibility of this is housed in the Judiciary Committee, and not all crimes are impeachable, and not all impeachable offenses are crimes. But I would ask you, is impeachment limited to criminal acts?
Not at all, Congresswoman. In fact, it's important to understand that one of the most, that a significant theme in the Constitutional Convention was that when the delegates thought of possible impeachable offenses, they were trying to figure out the scope of them. They never listed something that was actually a crime. They listed things that were not crimes. And in fact, many impeachments have been based on things that are not crimes.
I'm going to go on to another question.
Sure.
Can a president be impeached for conduct related to improper exercise of his Article II powers, such as removing a subordinate federal officer? And let me add, would all communications between the president and, say, the Department of Justice always be protected, always be not subject to review or suggesting that it were inappropriate?
I think it's an overreach to suggest the president somehow can insulate all his communications with anybody from congressional inquiry. That essentially makes the presidency unaccountable.
So can he be impeached for the improper exercise of Article II?
Absolutely.
And can the president be impeached at least partly on his conduct or her conduct before assuming office?
I believe I've suggested both in my statement and in other writings that I think the presidency could be subject to impeachment for that. Yes.
And clearly the Mueller report in Volume 1 has talked about a number of incidences dealing with the Russian intrusion into our elections that seemingly this administration and the office of president was involved in.
At the very least, this committee is entitled to look into things. So you've got the Mueller report. The Mueller report obviously contains a lot of different things, such as possible acts of obstruction of justice. It's quite reasonable and legitimate for a committee, for this particular committee, to look at that and to ask whether or not more investigation is needed. There's nothing in the Constitution that precludes the committee. In fact, there's a lot in the Constitution that supports this committee looking at that material and deciding whether or not it does provide evidence of misconduct or whether or not it needs more evidence.
I thank the chairwoman. I yield back.
Okay, thank you. The chair recognizes the gentleman from California.